Okay, well, it's 5:05. Let's begin so we're not wasting any more time. So, welcome to the Written Advocacy Workshop. I hope this is going to be useful for you. I've included some tips that I personally wasn't given. Well, I guess I was given most of it, but I've added a few tips and tricks that I've learned along the way as well. So, hopefully, that is helpful for you guys. And just before we begin, a little bit about who I am and how you guys can find me. I'm Donna. I'm a second year GE LLB student, and I was a moot finalist in the CSM competition last year. I won the Martin Dockeray Mooting Prize, and I'm now head of advocacy for this society. So if you guys do have any questions, you can drop me a chat on the WhatsApp group chat or just contact me on LinkedIn if you want, if it's wider law related questions and not relating to mooting or anything like that. But moving swiftly on. So we have two main elements when it comes to written advocacy. We have something called a skeleton and we have something called a bundle. And a skeleton is when you read the moot problem and you've seen it for the first time, you will write an outline of your main arguments. And that is what your skeleton is. And your bundle is what you will submit closer to your actual competition. And it's a massive document, sometimes around 200 pages, depending on the length of the cases that you've picked. But I like to start it with a little title page to make it look all nice and neat. And then you've got a contents page, the moot problem, a copy of your skeleton, and all your cases in full. So every single page of the case that you've decided. And I will go into each of these more so you guys can see what an example looks like, what to avoid, what to do. And we will go through any questions you guys have at the end. So first things first, a skeleton. This is what an average skeleton looks like. This is actually what I used for, I believe it was round two, I want to say. Yes, senior appellant. And essentially, with your skeleton for this competition, CSM in particular, you want to try and fit all of it onto one A4 page. And you can extend it to about two A4 pages. I did see a couple participants do that last year, but I know that judges really do appreciate conciseness and they don't want to have to be flipping through pages when you refer to submission 2B, for instance. So try to keep your submissions nice and concise and to one single A4 page. I'm going to now go through the structure of how you might want to organize the page and where you'd get this information from. So this is quite tiny, so I'm going to zoom and let me know if you guys can see. If you can't, I will see what I can do. Here we go. Right. So as you can see, the thing on the left here is the problem question, and it will look like this. You'll have City Scholars Moot at the top. You'll have in the Court of Appeal, Criminal Division, on appeal from the High Court or whatever court you're arguing in, and it will depend on what round you're into. So I think the starting round is probably something like contract law, and then you'll move on and it will be a different area, a different module. But as you can see here, I've written number one, this information over here in the Court of Appeal. That is exactly what will go on your skeleton right at the top, where I've written in the Court of Appeal, Criminal Division, on appeal from the High Court of Justice. And you see the one and the one, they match. So you can see where I've gotten the information from. And in the moot problem, number two, this is where you have your respondent and appellant. And that's exactly what you will do on your side as well, where I've written two. And then it gets to these little technical formatting parts where you've got these two lines over here and you've got skeleton argument on behalf of senior appellant. And I think we have a template that we can give round, but that template isn't always, it doesn't always work depending on, yes, I shall share the slides. I will do that. They will also be posted on Instagram, which is why they're so tiny, which is why I've decided to do them in this format. So hopefully when you're scrolling through Instagram, you'll see these two. But yes, so in terms of getting these two lines, I'm going to go a little bit on and on about this. But the template, for some reason, on my computer just didn't work and I couldn't get those two lines up. But if you guys can figure that out, great. If not, just click insert line on Word and increase the thickness, and then you can just move it up. And then that's what I did to get the 2 lines, basically. And as I've written here, skeleton argument on behalf of senior appellant. When you guys first get your moot problem, you will also be given a position to argue on. And that could be a senior appellant or a junior appellant. And don't be put off by the name of junior and senior. It is just about what ground you will cover. And it's not necessarily like a symbol of who's more dominant or who has the edge in the competition. It's nothing like that. Although I did think it was at the start. So it's a fair assumption. And I like to put that information in the corner over here, where I've written number 4, your name and your position just underneath, so that if the judge needs a quick reference as to who you are, what you're doing, they can just look to the corner of the page. Okay, let me know if I'm going too fast. I feel like I'm speaking at 100 miles per hour, so maybe I should slow down a bit. Right, then the next part. Your second page of the moot problem. Are most of the moots an appeal case? Yes, most of the time they will be an appeal case because it's just juicier. Then you have the grounds are based on what the initial judge said, and you'll have to say, oh yeah, no, the initial judge was wrong because of A, B, C, D. Most of the time it will be a court of appeal case. But yeah, no props. Okay, and then we have here, I've written number 5 as authorities. Where do you guys get your authorities from when you first have a problem question? And the best thing that I can recommend is that the moot problem question will most likely have some suggestions for you guys. For example, here in this moot problem, I was given LIDAR, Adamako, and Kennedy, and I thought, okay, great place to start. Let me start with those. And is it relevant to my ground of appeal? It was. So I added those as my authorities. And a lot of the time, if you want to find more authorities that aren't given in the moot problem, a really great place to start looking is, in fact, your textbooks. They are really good at like linking cases together in terms of legal issues as well, or even within those cases themselves that are recommended, they do link to other cases. Like Adamako might mention, I don't know, Kennedy, or vice versa. Oh no, it wouldn't have. It'd be the other way because it's a 2007 case. But do you see what I mean? There will be linking cases within the case that you're reading anyway. So yes, that's where I'd get the authorities from. And your ground of response, which is a quick, simple line. I wouldn't put too much of your argument in this part where I've written here, number 6, ground of response. It is quite simply this part at the end of the moot problem. It says, in preparing your moot, senior appellants and senior respondents should focus on the first ground of appeal. Junior appellants and junior respondents should focus on the second ground of appeal. So as you can see here, these two are the grounds of appeal. And if you're the junior appellant, you would only write down number 2. And if you're the senior appellant or the senior respondent, you'd only write down number 1 in this section over here. And you'd frame it as though this is your argument because that's your ground, right? It is just a quick statement saying, okay, this is the position that we're going off of. Right. Now we get to the more complicated stuff. If you thought that was complicated, we shall now move on to the submissions. Where do you get your submissions from? Essentially, a skeleton is your very, very basic argument. And I wouldn't put it past a skeleton and say it's a very simple thing and it's easy to do. I actually think the skeleton is probably the hardest part of your written advocacy because of how concise you need to be, especially because you have to fit it in an A4 page. And I remember last year when we were having this workshop and someone else was doing it for us, he said that we could have a numbered list, a lettered list, it didn't really matter. But I always prefer having 1A, 1B, 2A, 2B, because it's just easier to say. And you always have to remember, like, it's all well and good having a written skeleton. Is it gonna roll off the tongue when you're saying it to the judge? Are you gonna be able to say, oh yes, AII or 2AIB? I don't know. Do you see what I'm saying? Whatever rolls off your tongue easier, pick a list that works for you. And again, I said, start with the cases in the problem question, refer to the cases in the textbook. And this is where it gets a little bit tricky. But me and Sushant have looked over your moot problems for this year, and we've critically analysed them to make sure both sides are equal in weighting. So none of you should get us a side that is particularly hard or particularly unfair. But one of the biggest things that I've learned this year is if you have a hard side, consider how to distinguish your case from existing precedent. So if all of the case law is against your side, you're just like, damn, like, what am I going to do? None of this supports my argument. The best thing you can do is distinguish how your case is different to existing precedent and say, okay, no, my case is different because of this, this, and this is why we need to incrementally develop the law, for instance. Okay. And in terms of how succinct you need to be, I like to have my main argument in bold. So let's just say you've got your ground of response. I have three supporting points. The same way when you read articles or academic articles, one thing that I like to do, especially when I'm doing further reading, is know, okay, what is the author's argument and what are some supporting points they make to add to that, right? And that's exactly what you want to do with your submissions. I have three supporting points to my ground of appeal, and then I have sub points within that where I say, okay, there's a little bit of detail I'm dropping here, another little bit of detail. A lot of people think, okay, I don't want to give too much away because, hey, if I write everything in my skeleton, then my opposition is going to know exactly what I'm going to say and they're going to have something ready to go against me. And you know what? That is thinking ahead. And I will show you how you guys can leave gaps, if you know what I mean, in a strategic way. But do I recommend leaving gaps right at the start? No, but we will get onto that a little bit more. In terms of how much you'll be judged on more than just, I can't read all of it. Let me see. You'll be judged on more than just the legal correctness of your arguments. The aim of the moot is to help you with advocacy yourself. I'm sure they're responding to comments. Let me just carry on. I'm sorry if I do not see your questions, by the way, guys. I'm going a bit too fast. There we go. Let me make sure I can see. All right, lovely. Yes. So your argument is not a secret weapon. The judge most definitely needs to know what you're about to argue before you're arguing it. And if you start going off on a tangent, they will say, okay, sorry, what part of your submission was that? So if you have an argument that you haven't put in the skeleton and you've realized later on, okay, like down the line, oh no, I need to add another point, but it's not in my submissions, and I just need to bring this up, I would say apologize to the judge first and foremost and say, I know this isn't in my submissions, but I would like to add, I found a case just the other day and this is what was in it. And you'd have to apologize and work your way around, but I wouldn't recommend doing that, and I'd stick to those submissions. So do not submit your skeleton unless you're fully sure what your argument is. But now we're going to have a little bit of a look on bundles, and then I will go back to how we can strengthen our arguments, how you can write succinctly, how you can be a bit more persuasive in your writing. But this is something that I didn't learn until the final round, which is crazy because my feedback from rounds 1, 2, and 3 did not include this. So you're getting it for free right now. But first things first, especially if you're undergraduate, first year, second year, you might right now be using the Westlaw versions of cases. So you might be pressing this button over here and clicking download, right? You might be doing that, which means your case at the end looks like it has like Westlaw at the top and it has a case in its full. But that apparently is not what we're meant to do. That was one of the main reasons my written advocacy for the final round wasn't good, because I was using the Westlaw version. So sad. So what you guys should do instead is click this. So don't download it from over here. Go to the official law reports and click this little PDF button. I'm gonna make it big so you guys can see what I'm talking about. Click this and then use that in your bundle. Do not use the Westlaw Lexis version. Okay? It's a quick point, but something that needs to be noted nonetheless. And we are going to swiftly move on to tabbing, which is where you guys have your bundle as a whole. And in your arguments, you might refer to a certain section of a case. And what I noticed was the feedback for some people when we were doing this was that they had highlighted too much. And something that actually in my first round, the judge really appreciated was me underlining exactly where to look. So obviously, I highlighted the quote that I was going to use, but I wanted to particularly draw her attention to the underlined sections. And then she said, you know what, I really appreciated that because I could just see it instantly. I didn't have to do the work of like scanning and listening to you at the same time. So again, I know it's quite hard to do the underlining because if you don't have an iPad, I don't actually know how you would do it. Whereas the highlighting, I think anyone on your computer, you can actually just, I think it's over here. You press highlighting over there. Can you see me? I think you can. And you basically highlight on the PDF document. But there is also a disadvantage to underlining exactly what you want the audience or the judge to know. And can anyone guess what that is? Why would it be perhaps a little bit of a disadvantage to underline in particular what you want to pay attention to? Let's see if the chat's coming up with some ideas. I wish I could see the chat. Why is this so annoying? Let us see. Any ideas? Tuning message. Opposition will be able to rebut. Exactly that. Exactly that. That is exactly it. So that is one of the disadvantages, and it means they can pre-prepare an argument and just absolutely smoke you when it comes to, especially because these competitions, I don't think we're doing rebuttals this year either. It means if they can predict your argument and just address it anyway within theirs, it does make theirs look stronger. So there's a bit of give and take, you know. It's up to you what you guys decide to do with that information. But in terms of the bundle itself, not everyone did this, and again, completely optional. But I had a title page, and this is what my title page looked like. I just stole this logo off of Google. And I also stole our little logo as well, and I just put it all in one. No comments to this. I just thought it was pretty, so I like to do it. But what you do have to do is a contents page. And this is what it looks like. Again, same information that you had in the moot problem up here and here, and you just put your index in between two lines. It is just a way of allowing the judge to see what is on what page, where is everything located, etc. And some people had a really cool thing where they had links, like hyperlinks within this, where you could just click it and it went to the page. But I was not that tech savvy. So if you guys can figure out how to do it, I'm sure they'd love that. And another thing that I thought some people did was having automatic pages numbered. But I couldn't figure that out. So I wrote it by hand on every single page in red. So again, not something that you have to do, but I think judges can just Command F and then find the page number that you're referencing anyway. So again, totally optional. Now we're moving on to how to formulate a good argument. And these are some books that are literally available in your library right now that you can go and read. And I'm sure they'll do a much better job than me at explaining how you can have a good argument. But I have got a few excerpts from each of these that I thought were kind of good to look at, actually. So, starting with this one over here, this book. This is one of the pages that I thought was quite interesting. The ultimate objective, persuasive arguments. And it talks about ethos, pathos, logos. And I thought this was quite interesting because it is something that I paid attention to without really consciously thinking about it, if you know what I mean. But if you have that in the back of your mind now, you'll probably be at an advantage as well, because the first thing is your credibility with the audience, i.e., how do you come across to the judge? And I'm not saying you should riz her up or riz him up and say before the moot you try and, like, you know, get your way with. I'm not trying to say that at all. It's just coming in smart, looking professional, not being on your phone. But I'm sure we'll go over this as well in the oral advocacy workshop tomorrow. But in terms of how you come across, it is speaking with gravitas. Does anyone know what gravitas is? I know that's quite a difficult question, actually. But it is simply having aura. I think that's a good way of putting it. Moving on. Pathos. It refers to the emotions that you incite in the audience. And I don't know if anyone's had Dr. Tom Bennett, but he taught last year, and he was an incredible teacher, and he was also a mooter. And he actually taught me how to use emotion in your arguments as well. Even though your written arguments, you might have some kind of legal framing that tips the emotion in a certain scale, you can also do that orally, but we will go through that tomorrow. So trying to frame the argument in a way that would, tip the judge's emotions in a certain direction. So for example, in this Adamako case and this actual round 2 moot problem, let me give you guys like a quick summary of the facts because I thought it was so interesting. I don't know how many of you guys have done criminal law yet, but that is one of the great things about this moot competition. Like sometimes you wouldn't have covered what we ask you to do, and you will be ahead of your class because you will have to read up on it yourself. But in this case, as I remember, the mother had asked the aunt, so her sister, to look after the mother's son because the husband was low IQ. And when the aunt slash sister came over to look after the son, they both got really drunk. They had 2 bottles of whiskey. And essentially what happened was they both forgot to give the kid his meds and he died because of it. And I remember in my oral advocacy, I said, oh, they had a little bit of whiskey. And I was trying to emotionally persuade the judge to think, oh, yeah, like they didn't have that much alcohol, 2 bottles of whiskey. Who cares, right? But he did pick up on that and he said, actually, is 2 bottles of whiskey a little bit? You see what I mean? So take what I say with a pinch of salt. Obviously, you want to frame it in a way that is good for your side, but keep in mind that the judge is not stupid, essentially. Right. And logos, which is your logical flow. And I will go into this a bit more because I found another extract from another book that I thought was really useful in how to get from point A to point B. But I think the best thing that I can recommend for that is actually explaining your arguments to someone who has no idea about the law. So I think what I did last year was I just basically told my boyfriend the entire case stories. And I said, okay, these are the cases. Pretend you know what the cases are now. Let me tell you my argument. Do you understand what I'm trying to say? And if they say no, don't take offense because it means your argument is not good enough. And you have to think of your judge as a 5-year-old that you have to hold their hand and explain the entire argument to. And again, I will go through this more tomorrow in the oral advocacy workshop. Regular eye contact is quite important because obviously you have your written argument, but do you want to rely on it? You want to have it up here. But again, more on that tomorrow. Even gesturing, more on that tomorrow. Avoid angering the judges. Oh, this is one that I learned in the final round, which was hilarious because he asked me, okay, so I gave a definition and I said, this is the definition of ABC. And they said, okay, where did you get this definition from? Like, what makes you think this is the right definition? And I was like, oh, sorry, do you have like an alternative definition? I'm happy to run with that. And everyone just went, what did you just say? And I was like, oh, damn, like I'm not meant to say the judge isn't, like I'm not meant to question the judge. You're meant to just stand your ground and say, okay, no, this is where I got the definition from. This is the current precedent because of this. And you just have to stand your ground. So judges will try to trip you up sometimes, but don't worry about it. And logical flow. Here we go. This I got from this book over here, How to Moot, which is a great one. And they talk about simplicity. And again, I did not underline this book. That was not me. I did not graffiti this, but they speak about how it is hard to achieve simplicity, but it lies in the mastery of clear logical expression. And I really like the example that this book gives, actually, where you have this example and they've kind of dumbed it down quite a bit. But all Romans are men. Caesar is a Roman, therefore, Caesar is a man. But an invalid version of that would be all dogs are male, Caesar is male, therefore Caesar is a dog. Obviously not. So again, what this is trying to explain is that your argument should have logical progression. And I think the only way that you can actually do that, and you will not get that on the first draft of the skeleton, so don't submit your first draft, but try and have a logical flow to your answers. And I had one more thing from this book, which I thought was good, which is this one over here, which is not to pad out your skeleton. I know it's quite tempting, especially because we've been taught as academic writers to say, oh yeah, it is of great importance to say this, or, we should give serious consideration for XYZ. But you don't have the words for that, and you don't have the space for that. And you think that you might be like really clever and decrease the font size so that you can fit more into the A4 page, but try not to do that, basically. You just need to cut down. I'm really sorry, someone's car alarm is going off. You just need to try and cut down the words and be as concise and precise as possible. And okay, here we go. The secret art of leaving gaps. Now, this one I'm a little bit hesitant to go over because I think I don't want to mislead you. So don't leave obvious gaps, especially in your skeleton, especially in your bundle, because it will just make you look dumb. And I remember I tried to do this in practice, and my boyfriend was like, yeah, but like, why didn't you answer this question? And I was like, oh, wait, I know. I just want the judge to ask me about it. So ask me about it. And he did it, but he was like, I feel like it just makes you look a bit dumb. Do you know what I mean? And I was like, okay, right, I just need to add this into my main part. So where you can leave gaps is the more nuanced areas where you think the judge might ask you a question. So let's just say you've left about 3 gaps where you think, okay, the judge could possibly ask me about it. Fine. But if the judge doesn't, and you think, okay, this is going to really strengthen my argument, try and leave a bit of time in your oral speech to cover it if the judge doesn't directly ask. I remember, I think I left like 2 gaps in one of them, and she didn't ask me anything about it. I was like, I've left such glaring gaps, and she just didn't even pick up on it. But I managed to cover it because I was like, actually, I also want to add that this is also a really important point, you know? And you might even find a way to bring it in to a question that may not seem completely relevant, but they also pick up on that as well. So, yes, if you do have more questions about it, I will try and answer. So, some of the things that I have personally learned um, in my mooting journey is that do not be tempted to read between the lines of a case. And I think this was especially important for me in this final round of my moot competition last year, because I don't want to give myself excuses or anything like that, but I had the quote unquote weaker side, or whatever you want to call it. And there wasn't much legal precedent around my issue. And I was thinking, okay, like, what can I do with this? Okay, I have the case of Padfield. You know what? The judge does talk about this. Maybe I can try and bring it in. And I got absolutely destroyed for it because it just wasn't relevant. You just have to make sure you're reading your case as a whole. Just because they talk about one tiny weeny bit in obiter that you think is relevant, it may not always be. So always read your case as a whole. And if there is no precedent, so be it. So be it. Do not try and fit something that doesn't relate. And let me see what else I've got. You cannot skip reading a case that you've cited in your authorities. Oh, yes. So a lot of people think, oh, yeah, I can just put this through an AI and get what the main arguments of my case is so that I can just go through it. And would I recommend doing that? Maybe if you're pressed for time. But ideally, you do know these cases back to front, because the judge could ask you a question about a random page that they found interesting. And if you don't know what it's about, it just looks really bad, you know? And I think something that perhaps relates to both written and oral arguments is when you have your written argument and you want to follow that flow, because, oh yes, 1A goes to 1B to 2A to 2B. Would you then have to memorize every case? No, you don't have to memorize every case. I know I may have sounded like that because I said you need to know it back to front, but it's more so knowing who were the judges, what were the case facts, what was the ratio, what was the outcome of the case. And, was there a dissenting judge? Because they sometimes, if there is a dissenting judge, they might pick up on that dissenting judgment and say, but what do you think about this dissenting judge? Don't you think he was right? Then you'll be like, I don't know. So not necessarily memorizing absolutely everything, but just knowing what the key parts of a case are, and especially if there is important legal issues that are covered in that case that may contradict yours, definitely know that as well. Yes, you do not have to memorize every word. What was I saying before this? I completely forgotten the track of thought I was on. But yes, we shall move on to questions. So just the judgments and key elements. Yes, that should be completely fine, essentially. And I have whizzed through this pretty quickly, but I do not want to waste your guys' time. And I feel like I have covered everything that I thought was important, and I will share the slides with you guys. But does anyone else have any questions at all about written advocacy or even oral advocacy if you guys can't attend tomorrow? And feel free to just put your mic on as well if you guys are just like typing it out.
Yeah, I was going to say that you can unmute yourself.
Yeah, and Sushant, do you think? Yeah, go ahead. Yeah.
I just had a quick question. If like some of the authority you're using doesn't exactly match your argument, do you think it would be worth saying to the judge something like, oh, I know on the whole it could be seen that this doesn't actually match, but in paragraph whatever, or not?
This is a good question, because I feel like this is what I did last time, and I got my poo kicked in, basically.
Sorry, could you repeat the question?
I think the question is, if it doesn't exactly fit, should you just tell the judge and say, this part I find convincing? Is that it?
Is that if you've made a mistake? Is that if you've made a mistake?
No, like if most of the case you've chose, like if some of the case you pick doesn't exactly match your side of the argument, but you're still going to use it because you can't find much else to add, like saying something like, oh, I know on the whole it may seem that this case doesn't match, however, in this bit, I don't know.
I'll take this question if that's fine with you, Donna.
Yeah, go for it.
So there's multiple reasons why you would take a case that doesn't wholly support your argument. Is one, if you're rebutting your opponent's arguments. Sometimes it's fine to have quoted a case in your authorities on your skeleton, because skeletons are due 48 hours before the moot and bundles are due 24 hours before the moot. So if you quote a case on your skeleton and you happen to not use it later, or you don't put it in your bundle, it's completely fine. But that's because you anticipated an argument about 48 hours before seeing your skeleton, before seeing your opponent's skeleton, essentially. So you can include a case. You don't need to always expressly mention that it's not a case relevant to you. If it is a case that you've used as form of a rebuttal, and by the way, when I say rebuttal, it's not openly objecting to your opponent's arguments. It's during your 12 minutes of speaking time, which you will have, making a submission based off your opponent's skeleton and saying that my learned friend would refer to this case, and I would like to rebut this presumption, XYZ, whatever they go on about. So yes, if a case is not wholly relevant, you can always include it. Sometimes judges do have comments that make comparison to a previous case. Another rule about the Court of Appeal is they're not bound to accept their own decisions. So, for example, if the Court of Appeal held in 2005 that 1 + 1 is 2, they don't have to accept it maybe even 10 years later in 2017. The Court of Appeal can basically say 1 + 1 is 3. They're allowed to overrule themselves. but in overruling themselves, they have considered a decision. So when you do give or quote a case that does not support your argument, you're basically asking the judge in your case to consider the reasoning um, of the said case. Yeah, so you're essentially allowed to use a judgment that's weak to your point or has only one element of it that helps you. But the way the moot questions are focused, I doubt you will run into a issue of that nature. Yeah.
Yeah, I remember last year as well, just to add to that, I did use a case that was only partially relevant. And I remember my opposition, he picked up on it immediately and was like, that is not what this case was about. This case was about XYZ. That was just obiter. That is just not relevant. And again, it just looks bad. So as long as your opposition doesn't do that, you'll be completely fine, hopefully. And yes,
Yeah, and sorry to cut you. Sometimes
mhm.
your opposition might approach you a day in advance or something and probably go on about, I mean, right after your skeleton has been released, sometimes your opposition is your classmate, so you're bound to talk. Don't worry if they say something that doesn't align with your understanding. It's completely fine because when I mooted on the City Scholars, I had one of my friends who happened to be in the same group. I was a junior, he was a senior. Arguments between the senior and junior cannot really align on concept, though they are roughly limited to the overall concept. It's fine if someone does come and say something to you. Don't take it to your heart. Don't go off track. And yeah, some people can be annoying, is what you want to call them. Yeah.
Yeah. Also, Sashan, just a quick one. What was our authority limit again? Was it 6?
We have a limit of 5 authorities.
Oh, fine.
Again, you don't have to use all of them. Um, you're completely fine to use 3 or 2. Depends on your argument.
Mm.
And as Donna did say, there's no limit on your bundle. So in practice, the standard practice direction is include the full case report. Now we will not recommend you do this for the first round at least. You're completely welcome to do it. You don't have to print the bundle. The submissions are all online and the judge will have a digital copy. So yes, your bundle can, in theory, be 400 pages, 500 pages, but that's only because you've included the whole law report. You do not have to highlight all 500 pages. When you're reading on Westlaw, you would have probably already found what paragraph you want to highlight. So essentially, just take the judge to the same page, and you're fine. So yeah.
Yeah, I think we also had another question after the. Oh, sorry. Did that answer your question fully, or did we just ramble on and just not answer it?
Yeah, no, that was really good. Thank you.
Okay. After the problem question has been released and we begin preparations, what do we do then? Would we wait for the start dates of the moot, or would we have in-person workshops and training sessions? I believe yes, if you sign up for the moot mentorship, right? Or not unless you do that, right?
So the moot mentorship program is independent of the mooting timeline. We
Hmm.
do have that as a program available to members only. It's completely fine if you don't get onto it because we can always answer any questions you may have. But um, where there is an increased demand from students who are participating, saying that they need a workshop or they have certain clarifications, we don't mind hosting one on demand. Um, we do have our own head of advocacy, Donna, who's made it to the finals, and certain other senior members of the society or one of our colleagues from last year. Um, so yeah, we don't we haven't scheduled workshops during the whole moot prep period, but the way it works is when the PQ releases, um, You will have 2 to 3 weeks, depending on which round it is, to prepare your arguments. And then, yeah, if you have any questions, we're open to clarifying. Sometimes, at least last year, we recognized that there were certain errors of law in the problem question for GDL students, and I think maybe for CSM. But yeah, if there's issues like that, we always clarify and we're open to questions.
Yeah, I think
Yeah, I
there's
hope.
also been a question of like just the scheduling of each like when is the problem question released, and then what happens, and then what happens, and when do you get feedback, and when do you decide who's been through? Is that it, or have I read that incorrectly? I hope
It may
that's
or may
right.
not have been that, but we can answer that question either ways, actually.
Yeah.
Yeah, a simple way of putting the timeline is, if I'll use blanket dates, I'll just use a random date on the calendar. Um, if the problem question was released on the 20th of October, um, you would have 2 weeks to prepare. That would mean your advocacy round is probably on the 3rd of November, 48 hours before. So just because this is not a professional setting like a court, we allow submissions over the weekend. So 48 hours before Monday, 3rd of November would be 1st of November, 6 p.m. You would be uploading your skeleton to Microsoft Teams. And then Sunday, 6 p.m., 2nd of November is when you'd be uploading your bundle. After your oral round, we ask about 1 to 2 days to process all the details. You will receive an email and you will receive your outcome of whether you've progressed to the next round or not. So that's how we're functioning. Your
Yeah, we're trying
feedback
to
would be in the
streamline that
same
as
email.
well.
Yeah,
Yeah.
there's been a lot of effort in making this feedback process more compact and detailed. Um,
But yes, I think she said that's okay. So the next question is uh, the structure, skeletons, and bundles. Should we use the template that you've presented here? How do we know best to word them? I use the template that they gave me. So this is actually based on the template from last year. So again, the title page was not included in that though. That was a little bit of me. So if you want to add a bit of that, you can. But
yes,
again,
you're always welcome to add things to your bundle. I
yeah,
don't
exactly.
Judges actually like that, as long as you're not swaying away from the topic or trying to
Yeah.
distract them. So yeah, cover page is actually a really professional addition. We always have that in practice. We
Mm.
will again be, so for this year, we'll be putting this sample structure documents on our website, which would also be linked on the Moodle page. So yeah, you will have access to the right documents. As for wording, when you say wording, I assume you're talking about the language and style of writing in
Yeah.
these documents. Um, Adopt a professional speech. You do not have to complicate it. You don't have to use old English words.
Yeah.
Therefore, thereby, henceforth. Don't glorify your work.
Mm.
This is one of the feedback some students do get from judges, is that your skeleton is a piece of legal argument, not Shakespearean poetry. Please don't
Yeah,
complicate
exactly.
it. And yes, once you do enter practice, you will see that legal documents are actually not written in the most complex form. They're simplified so a layman could read it and understand what the case is about. So language and style, keep it normal, simple. If you read your textbooks, you most textbooks actually reflect the kind of language you should use. The only thing we'd probably suggest is ensure you use the right terminologies. So if it's a case for, let's just say if it's a criminal case, ensure the words causation, omission, responsibility, reasonable foreseeability, these kinds of words are always there. Because If you paraphrase them into something else, there's a chance you'll miss out on the concept and you'll
Yeah.
probably twist your arguments. Yeah.
Yeah. I think again, like the books that we recommended were quite useful in that actually. They give so
Yeah.
many examples as to how you should word them. But I think what Sushant said is very useful as well.
Yes. And as Donna did, use the library. It's there for your assistance. I'm gonna deal with a few smaller questions in between. So yes, two moods were released, the GDL and then the scholars. You will hear back by the end of this week, early next week, um, on whether you've got a spot or not. If you were not able to attend last week's workshop on introduction to voting, we do not, that in that workshop, I mentioned that we do not expressly reject anyone's applications. We're only checking if you actually completed the form and have the motivation to participate. Um, and if by any chance we've had more demand than available spots, we will try to introduce a shorter, different competition. So yeah, but everyone will receive an email whether you are on the competition or you aren't. So no need to worry about that part.
I think the next question is actually so good, and I had this exact same question when I was doing my moods as well.
Go
And I
for
think
it.
maybe we
What's
should
the
say it out loud as well, so that that's in the recording. If you're planning to rebut how the opponents are interpreting one of their authorities, do you have to include that authority in your bundle, or do you only include the authorities from your personal skeleton in your bundle? And should you ever include a rebuttal in your skeleton already, if there's clearly a case that will support their side and you want to preempt why that's flawed, or does that always only come up in the oral submission itself? So Sean, why don't you handle this one?
um great. So if you've and one when it comes about authorities, there's a high chance, at least on these modes, that the authorities between you and your opponent are similar. It's just you're looking at different pages of or different reasonings of the judges. The Court of Appeal does not have a single judge that makes a decision. You have about 3 to 4 judges, 3 5 judges making decisions. Sometimes you would refer to probably judge one if it helps your argument, but then another advocate may refer to judge three because it helps their argument. So, yes, there's a chance that case is already there in your bundle. If not, you're welcome to include it if you're going to be spending a lot of time on the rebuttal. But we always advise do not spend time on the rebuttal. Some judges are iffy about that. They don't appreciate rebuttals and academic notes. It's just not to say you should never include it. You're free to include it. Um, your rebuttal is probably 1 minute at the end of your submissions. Never include your rebuttal during your main submissions. Go through your first, second, and probably third submissions, which prove your case. And then, if there's time, go on to do the rebuttal. So, one, authorities, there's a high chance it's already there in your bundle. Two, if it's not, you're free to include it. And if you don't get time in the end, it's fine. You never used it. It does not count. It does not mark you down for being incorrect or anything as such. And should you ever include a rebuttal in your skeleton? I think I did that once personally. You don't have to because you cannot update your skeleton um, once you've sent it. So both
But
of
also,
you,
so Sean,
yeah.
like just before that, I think she's asked. Maybe you said it and I just completely like missed it. But let's just say like they are using an authority that may not necessarily support your argument, but you want to tackle what they're saying. Let's just say it's after they've submitted their bundle. What should they do then?
Well, that's where it becomes a bit tricky for judges because I, as an advocate, at least on these moods, you cannot refer to another person's bundle. You cannot particularly take the judge to, you can't ask the judge that, Judge, may I please direct you to my learned friends bundle
Mm.
page 200.
Yeah.
You have to only use your own bundle. So
Yeah. So it's the safest thing to do is just put the
yes,
authority in your own bundle, or perhaps maybe have a
or
slight
just not
sub
make the
point,
rebuttal.
or
Yes.
just don't do it. Yeah.
Um, it is very ambitious at times to think that you'll have time for rebuttals, but then a judge will intervene. Um,
Mm.
in fact, both scholars and GDL mood, the judges have been instructed to intervene at least once. And when I say at least once, the maximum is twice. So yeah, the judge won't continuously interrupt you, but um, with that and allowing every participant enough time to make the submissions, there is a chance you won't be able to make rebuttals. Um, so yeah, if someone has included something and it's not there in your bundle, just let it slide. It's fine. If you find another professional way, then sure, go for it. Sometimes, I think I once rebutted my opponent's arguments by not even using the case they relied upon. But if you can visibly see there's two cases, one in your bundle and a completely different one in your opponent's bundle, but your bundle actually, your case deals with that rebuttal, just use your case. We've had advocates using two different cases, one that was overruled as well. Sometimes you'll find your opponent using a case that's no longer good law, is what we call it in
100%.
the
Yeah. And I
field.
completely missed that as well. Just make sure you're using like the highest court of law as where
Yes,
possible. Don't use something that has been overruled. Try go to the
yes,
Court of Appeal, Supreme Court cases, because at the end of the day, you will be arguing in the Court of Appeal. So remember that only the Court of Appeal above them and the Court of Appeal
yeah.
itself is binding on them. So a high court judgment may not necessarily bind the Court of Appeal. So I
Yeah.
completely did miss that point. But yes, that is a
Um,
very important one.
yeah,
And
if you're in the Court of Appeal, only use another Court of Appeal judgment, or
yeah,
at least
a
House of
Supreme Court
Lords
one.
is what they were previously called, and the Supreme Court judgment. And
Yeah,
even between House of Lord and Court of Appeal judgments, you will see that they've been overruled by a later judgment. Um, the more you explore Westlaw or Lexis, the
yeah,
more you actually see how and where those cases have been cited.
yeah.
Um, yeah.
Also, if I could just quickly add to that, in terms of could you ever include a rebuttal in your skeleton already? I think obviously everything that Sushant said still stands, but if you're desperate to add like something sneaky in there, you could do it as like a sub point within your submissions. As I showed you guys in the skeleton, you've got like point one, then you could have A and then AI, if you know what I mean. Like the I point could be the rebuttal, and it would be like in a passing moment. So it doesn't have to be something that you hone in for like ages and ages and ages. But if you're desperate to include a rebuttal, then you could do it in a more subtle, nuanced way, basically. But again, at your discretion.
Yeah.
Is it the same, or have I just skipped one? Have I skipped a
Um,
question?
there's a question on if the skeleton format is the same for other areas, example, family law, contract law. For most of
Mm.
it, yes. When you say the skeleton format is the same, I assume you mean how it looks overall. Yes, it is. So you would always have the name of the court on the top left, claim number, and what term you're sitting in. So you've got the Michaelmas, Hillary, and Trinity term. These are the legal terms. You don't have to learn them. They're always given on the header of the problem questions we give you, so you can practically copy paste them. But yes, that, and then you've got the respondent, appellant. Criminal cases, you'd always cite the crown. So since it's a king, now it's Rex and whoever is the appellant. If it's a civil case, which means contract, civil, contract, or anything else, you'd state the claimant and respondent, which would then essentially become respondent appellant or appellant respondent. essentially the header of the document would always be given in the mood problem. It's just for you to recreate it. And then if it's family law, practically the same thing. There's no material difference between any of the different areas of law. What changes is the substantive content and the procedures you're referring to. Of course, in a criminal case, you won't refer to a civil case or tort principle. So those are the differences essentially.
Yeah, and I think there's been a question on. I know in some moots the judge is told to ask questions during your speech. Will this be the case? I know we said yes, 1 to 2 questions, but I actually remembered the point that I got distracted with. So what I was actually going to say is that sometimes a judge will ask a question that is relevant to point 4 of your skeleton, but you're still on point 1. And something that they hate is when you say, "Oh, wait, 1 second, I'm going to get to that. Don't worry." Like, "Oh, I'll answer your question just in a little bit." I think they really dislike that. And I think the whole point, and I will go through this tomorrow in oral advocacy, is your ability to move through your skeleton flexibly. So having a script that works almost in reverse and you can like pick and choose like where things can go. So even though your skeleton is there, yes, and you're going to go from submission to submission to submission, you may have to like weave in number 4 and number 1 because they've asked you a question on it. So don't be married to your skeleton, basically.
Yeah. And this is another thing some students end up doing is treating their skeleton as a script.
Yeah,
Never essentially do that. Let your skeleton be an independent document for you to follow um, the order of arguments and not make it a script you read off. It's fine if, and it's actually very common that the wording of your skeleton and your speaking style is the same. It's just one's written and one's being oral. It's fine, but don't make it sound like you're reading off your skeleton.
yeah, and I think that was great. Will there be more opportunities throughout the year to moot internally if we haven't applied yet? And does the City Scholars moot happen every year?
The City Scholars Moot happens every year. Um, who will be running it next year? I am not sure of it because, yeah, that changes almost every year. But so if you don't get in this year or you don't feel like participating this year, you're completely fine to participate next year. Of course, the sooner you do it, the sooner it ends up on your CV and the better it is wherever you're applying. Chambers and law firms actually look for you to have some advocacy experiences. Uh, as we've said before, even if you're planning to become a solicitor, advocacy experience is now part of the SQE route. So yes, that kind of stays on. Um, if you do it first year, second year, you'll have enough to talk about during your applications you make throughout second year onwards. If you do it in third year, it's no problem if you didn't do it. It's not a bad thing that you haven't mooted ever. If you're at a senior stage in your course, it's completely fine. But yes, we do encourage you not to delay it. Yeah.
Is our debate competition going ahead? Because I think that might be an opportunity to
Yes.
moot in the middle of term.
So we will have debate competitions which will start and end on the same day. You will, some people may find that interesting. Um, yeah,
And that's during
but
the year, so shouldn't be like a
yes.
set, like from term 1 to term 2. It'll just be, yeah, we give
Yeah,
certain
those sessions
dates.
are like around 1 to 2 hours and you'd start and
Yeah,
finish on the same day. The winner would be announced on the same day. Um, yeah,
more on that to
essentially
come.
that. Yeah.
Any last questions?
If I can share my screen, I will show
Should I stop
something.
share? Let's do that.
Yeah. Um, So this is Westlaw. I've picked a random case. I don't know what this case is about. I'm not going to comment on that. Um, as you can see, it says positive, neutral, judicial consideration. This shows the law is still in force, as in nothing has essentially overruled it. You can look at treatment where you will see related cases and cases which essentially have happened after this case took place. So this case, in at least, was decided in 2021. You will see cases in 2022 that have applied the case. This is a relatively shorter treatment map, but sometimes you will see cases that have overruled it or they have considered it. So it's definitely relevant to use Westlaw. There is an equivalent of it on Lexis, but I personally don't like Lexis, so I don't use it. Yeah, and then precedent map. This shows any cases that have been cited within this particular case, and it shows you the timeline of those cases. As you can see, there's one from probably 1999. If it shows red, there's a chance yeah, there we go. Makes judicial consideration, which means it was probably overruled, or many judges did not just consider it but never applied it. So it's tools like these that would be relevant in deciding whether a case is helpful or not. I hope this adds and helps to what we've been trying to prove with using the right cases.
I'm just answering this question because I think this is relevant to tomorrow, but maybe in case you're unable to come tomorrow, do you have any tips to move away from script reading? And actually, I know Sushant said don't use scripts, but actually I did use a script for like round 1, and then I also used it for round 2, but tried to limit it. But after, I think because in round 1 and round 2, actually the judges were a lot more lenient and flexible. They were like, listen, we understand, but for round 3, you guys better get off the script, because why would I not just read your argument? Like, the whole point is that you're like speaking your argument to me, and they really want eye contact for some reason. So what I did was I practiced like absolutely crazy. And what I practiced especially was practicing my submissions in different orders. And sometimes I'd go from 1 to 3 to see if I can bring it back to 2 and then 4 and 5. Do you see what I mean? Just practicing them in different orders really did help me. I also practiced in front of other people and asked them to ask me literally any question. It could have been on the case, it could have been on, what is this legal issue, anything. And that also helped as well.
Yeah.
Bye-bye. Sorry, I'm just saying bye to the comment.
Sometimes it's completely fine to have a script. I had what I would call a script. It was condensed into single points. So try putting the fact of your argument, or the actual authority and the point of the argument you're trying to make. And then it's going to naturally free flow into what you will eventually say. So yeah, you've got both ways, whichever suits you. Yeah.
I'm so glad we were able to cover everything in an hour. Like, I'm impressed. That was complicated stuff. Thank you so much, everyone, for attending. I hope you guys all have a fantastic evening, and I hope you guys can attend the oral advocacy workshop tomorrow. Feel free to always message us. We are available.